Okay, here we go. Good morning once again, everyone. Today we are going to be talking a little bit of labor laws, how to get your team from under the table, if you want to call it that way, to W-2, and how to understand the difference between a contractor and an actual employee. For that, we have Asha Wilkerson, sorry. Joining us. And I'm gonna pass it to her so she can introduce herself.
Thank you. Thank you. Thank you. So my name is Asha Wilkerson. I have been a licensed attorney, and I say licensed because oftentimes we tend to get legal advice from people who did not go to law school and don't have the license. And it can be very well-meaning advice, but definitely go to the experts because they have something to lose if they mess up, right? You can always go back to them. And if the advice is a mistake and it costs you money, then you have some kind of recourse, like also dealing with the CPA as well. That's not how I intended to start out this conversation, but that was my little disclaimer. I have been practicing law since 2009 in California. And in the midst of my legal journey, started teaching full-time as a paralegal instructor at a community college. And so I ended up bridging my knowledge of the law with my passion for education, and within my law practice started creating trainings and workshops for entrepreneurs about employment law, about contracts, about business law, things like that. So to be talking to you today about bringing your workers from under the table is something that is very, very important. And I want to make sure that you get all of your questions answered. First of all, before I really get started, does anyone have employees or have workers that you all are using to run your businesses right now?
I do.
Okay.
For the Being Kitchen.
Okay, good. About how many people do you have working with you?
On payroll, just 2, but we
Okay.
have a total of 6.
Okay, good. I like that, on payroll. Okay, this is just a little bit about me and my background. I do business coaching as well. I've been voted a California super lawyer. That just means that my colleagues respect me and respect the work that I do. I'm also a college educator, which really just means that I love breaking things down and making them attainable for folks. And I've been an entrepreneur myself, just running my own business, and I've counseled hundreds of clients on business and legal matters, which is what qualifies me to sit here and talk with you today. So today we are going to be covering the topics of wage and hour. Can you all still see? You can still see my screen, right? Okay. Wage and hour laws that are applicable to restaurants and food-based businesses. The differences between employees and contractors, oftentimes we know that there's a difference, but what I find is that, especially when we're starting up, we will skip the difference or skip the work of hiring employees and just go straight to contractors. And then there's penalties for misclassifying workers. And then I want to talk to you about the next steps so that you can bring your workers from under the table and just make everything legally compliant. So let's start out the good stuff first, right? The California Labor Commissioner and California employment law has these written wage orders that cover particular categories of work. And they're called the Industrial Welfare Code. The Industrial Welfare Code, let me just move this over. I have the, I should have set it apart already, but I forgot to do that. Let's see. I have it for you so you don't have to look it up. But now I don't know where I put it. And I have one that's all highlighted too. Where did it go? Okay, here it is. I'm going to put this in the chat. You should be able to download it. This is not the highlighted one. Come on, Asha. Okay, well, until I find, I'll email you all the highlighted one. Until I find that, I'll just give you the link actually so that you can go and get the most recent version from the Labor Commissioner or from the Department of Industrial Relations. You can download it. And then I'll make sure that I email this to you as well. I really want to find my highlighted one. I was so proud of myself for using the highlighter on Adobe. I thought it was so cute. Okay. Okay. I won't spend too much more time looking for it. My desktop probably looks like yours with 1,500 little icons of things that I've been working on at some point in there. Okay, so the Industrial Welfare Code has the laws that apply to us and into the profession. So that's one document that we really need to pay attention to as we're looking at the labor laws, also regular labor laws, including minimum wage, and things like that. And actually, that was the document. So I'm going to put this in the chat. You can download this. You might have to click on it twice. And then I will switch my screen to sharing right here. Okay, so I'm going to go through a couple of the laws that really stand out and are important to you as a food-based business. Now, the Industrial Welfare Commission has different wage orders for different industries. You all fall under the public housekeeping industry, and I have it highlighted here why. Because it covers restaurants, nightclubs, taverns, bars, cocktail lounges, lunch counters, cafeterias, boarding houses, clubs, and all similar establishments where food is either sold or liquid form is prepared and served to be consumed on the premises. So that's our catering, banquet, lunch services, and similar establishments which prepare food for consumption on or off the premises. So I think most of you all will fall under this wage order. The nice thing about falling under a wage order is that this becomes sort of your governing document. There's a few that you need to look at, but this can become your quick reference guide. So most of us employers are acutely aware of the overtime hours, and we're thinking about that a lot. In California, unlike some states, and federal law is different on this, but because we're in California, we have to apply the most protective law at all times. So any hours that are worked over 8 in one day or over 40 in 1 week jump into overtime. If you're looking at daily overtime, the hours, 8 hours and 1 minute until 12 hours is paid at time and a half. 12 hours and above is paid at double time. If you're looking at the hours worked in a week, hours over 40 are paid at time and a half. Okay, so if you're, I don't know, maybe you're getting ready for the holidays or doing a festival or something like that, and you look up and you realize, oh my gosh, someone has been working, from 8 a.m. and now it's 8 p.m. That's 12 hours, which means they have 4 hours of time and a half. Doesn't mean that you can't keep them there, it just means that you have to pay the higher wage, okay? And it's time and a half of their rate, or double time their rate. Okay. If at any time you all have questions, please, please, please feel free to interrupt me. There's more information here, but I think that's the most important. I will tell you to glance it over or get with somebody who's going to read it in and out and make sure that you have all of the elements that you need when you're hiring the employees. But as we move, also pay attention to child labor laws. If you have now your own children, you're good with labor laws. There aren't very many laws that are protecting people's own children, but if you're hiring a teenager, you need to make sure they have a work permit. There's a certain number of hours per week that they can work and things like that. So teenagers can be great. They can be great for a business. They've got lots of energy, young legs, all of that stuff. So just make sure that when you're hiring them, that you're complying with the labor law. Okay, minimum wage. So by California standard, minimum wage is $16 as of January 1st. what ages does this become? I think it's 17, where they're no longer child labor laws and protection, either 17 or 18. 18 would make sense, but I think it's 17. But we should definitely double check that. Minimum wage is $16 right now in California. Depending on what city you're in, your minimum wage may be higher. LA's is higher. I think it's 17 something right now. The best way, the easiest way to check is just to Google the minimum wage in the city where the person is working. Now, if you have, let's say, there's a festival or something, you're vending at an event or at a farmer's market. If the employee is working 2 or more hours in a city that has a higher minimum wage, you are responsible for paying the higher minimum wage for the time that's worked. So this used to happen all the time between Oakland, where I was living, in San Francisco. And if people were delivering in San Francisco or doing a pop-up shop or something like that, their employer had to make sure that they paid the San Francisco minimum wage for the work that was done in San Francisco if it was more than 2 hours of work at a time. If sometimes you may have split shift, maybe someone comes in for a couple hours in the morning and a couple hours in the afternoon. It says when an employee works a split shift, 1 hour's pay at the minimum wage shall be paid in addition to the minimum wage for that workday. So if someone comes in for 4 hours in the morning for the breakfast rush and then 3 hours in the evening, they get an extra hour for that split shift because it's not one continuous block of time. That's how it's supposed to work, okay? Reporting time pay. This is when an employee is required to report for work, but is not able to work. So sometimes there's a situation where you're not sure how many workers you're going to need, and you have 5 people show up. If somebody shows up, but there's not enough work for them to do, then you have to pay them a minimum of 2 hours, but not more than 4 hours. Right. So I don't know if any of you all would necessarily be in that kind of a situation, but I don't know, maybe it's well, I don't know. Would you all be in that situation? I won't go into more detail if you don't think you would be. Okay. I don't think you would be. Okay, this area, record keeping, is where people tend to get into trouble. So my advice is to do everything electronically, is to get a payroll system like Gusto or something else, and make sure that you have input your information and the employee's information correctly. Because as an employer, it is your responsibility to keep accurate information, which includes the full name, address, occupation, and social security number of the employee, the date of birth if under 18, and it should say that they're a minor. So under 18, I think, is when the child labor laws applies. Time records showing when the employee begins and ends each work period, meal periods, split shift intervals, and total daily hours worked shall also be recorded. Okay, it's important to have those documented because a part of your responsibility as an employer is to tell each employee with their paycheck, so at least twice a month, what their wages are, what the total hours worked was, what the applicable rate of pay was. So it's saying how many hours they worked at what rate. And if there's a piecemeal rate, like maybe they make $20 an hour for working in the kitchen, but make $30 an hour for delivery, that would be considered piece rate. Then you would have an explanation, $20 is for the kitchen and $30 is for delivery, right? Times the amount of hours that they worked. The good thing is that when you set it up in payroll, it's easy to just input the numbers in the right fields. But I have seen countless employers get into trouble because they haven't, one, not using a payroll system, or two, they're just putting in hours, but they haven't taken the time to get it set up. And I would spend the 30 minutes to an hour that it takes to set it up correctly, because then you've got it and you don't have to worry about it. So at the time of the payment of wages, there's an itemized statement. So like your pay stub, right? That shows the deductions, shows the time period that the employee worked for which they're being paid, the name of the employee's social security number, the name of the employer. and all deductions made on written orders of the employee may be aggregated and shown as one item. So you can put them all together, okay? In the US, even if you have employees that speak multiple languages, they still need the documents, the records still need to be in English and in ink. So I think you could probably add another language on there, but they also need to be in English. Right documentation, properly dated, right, month, day, year, and kept in a file. And clocks are also to be provided in all major work areas so that people can look up and know exactly how long they've been working. They can look up and see when they should be able to take a break. You can look up and see when they should be able to take a break, all of that. Okay, are there any questions about the record keeping? All right. Be straightforward.
There's a question from Mercedes that I think you might have answered, but just to cover it. What ages does this become applicable labor law? I think she was referring.
To the minors. So I think this starts to apply. The minors have a special type of protection until they turn 18. So 17 and below, or 17, 11 months and whatever many days. If you have uniforms, so I didn't highlight anything here in uniforms because I thought I would just ask you all whether you have uniforms. If you have like a branded t-shirt, then it is your responsibility to provide the employee with that t-shirt, with a couple of t-shirts so that they can wash one, come back to work in a fresh shirt. If you just tell them, hey, wear a red shirt in khaki pants, like Target, then they can be responsible for that. But if they're in a full uniform, then typically the employer is responsible for ordering the uniform, paying for the uniform, and keeping it clean and stuff like that. So think about how uniformly you want your employees to be dressed. If you can do it with some colors or maybe a logo t-shirt, then do that, because then it allows them to be responsible for taking care of their own clothing. You all, I'm assuming, don't have anything to do with meals and lodging. This would be if someone was, staying at a place, working remotely, like at a camp or something like that. So this meal periods and rest periods is also where people get caught up. So every employee is entitled to a meal period for if they work 5 or more hours. And it should be a 30-minute meal period. That meal period is unpaid if they are completely off work. Okay, so it's, 30 minutes that you don't have to pay if you relieve them of all of their duties. If they have to get up 15 minutes in to do something, then they get paid for that time period. This is important. Now, there's always a question about whether or not an employee can waive their meal period, and they can do that, but there should be a written agreement that states that the employee that they understand that they're waiving their meal period, but also that they can revoke the agreement at any time. So you cannot force an employee to not take a lunch. They have to voluntarily waive that lunch. If they work through the lunch, then you still have to pay them. So they can waive it, but you would still pay them for that 30 minutes that they would have taken anyway. If an employer fails to provide an employee a meal period, then the penalty is to pay 1 hour of their pay. So even if it's busy that day, as much as you can, please have people take a break or sign that they're waiving their break. And even if they do sign the waiver, and especially if they aren't able to take a break, give them an extra hour of pay and note it on the pay stub that it's for the missed meal break. Because what happens is, oftentimes, I think when employers start going off-site, sometimes employees are like, oh, I didn't get to take a break. It was too busy. There were too many people at the window. There was no one there to relieve me. There's only 2 of us working at a time. I couldn't leave somebody else there. And so sometimes the owner won't even know that the meal or rest break hasn't been taken until there's some kind of separation of employment, and then the employee has a complaint, and the owner or the company cannot then prove that there was a meal or rest period that was taken, right? So the documentation is really, really important. Really important. Same thing with rest periods. Each employee is entitled to a rest period for every 4 hours that's worked. As much as possible, try to put that rest period in the middle of the 4 hours. So 2 hours, then 10-minute rest break, and then another 2 hours if you can. Okay. This is also where people tend to get caught up as well, because, like, oh, it's just 10 minutes, whatever, it's not a big deal, or they'll wait for the employee to tell them, but that's not actually what the law requires. The law requires for you as the employer to make sure that you are giving the proper breaks. Okay. Any questions with that before we move on from this? Okay. Go back to here. So we talked about all these minimum wage, meal and rest breaks, and overtime. There is, of course, the IWC wage order that we just looked at, and then also just regular labor law that's in the labor code that you would have to pay attention to as well. So now we're going to move on to talking about employees versus contractors, because oftentimes this can sound really overwhelming. Well, God, it's so much work to get an employee together and all this paperwork to fill out. It is, but it is worth it to do it when they're actually an employee. So California says that any worker is presumed to be an employee, and you have to prove that they are an independent contractor. Okay, go ahead, Maybelline.
We cannot see your screen. I don't know if
Oh.
that's something. Yeah.
Okay, let me stop the share and maybe try again. Can you see it now? Okay, let me go back because I got a little bit ahead of myself. Okay, so there's an ABC test in California that says that a person is considered an independent contractor if they're free from the control and direction of the hiring entity in connection with the performance of the work. So typically that looks like if you have your business and you hire a bookkeeper to do the bookkeeping part of your business, you are not telling the bookkeeper how to keep your books. They already have the knowledge to do it, and so you're not supervising them. But somebody who is in the kitchen with you, making cookies, mixing the dough, that's a part of your business, and so you're telling them how you want it done, right? Also, a person who performs work outside of the usual course of the hiring entity's business, again, the bookkeeper does not make cookies, right? Your business is making cookies. The bookkeeper is doing a different function, but they're doing it for your business. They could be an independent contractor. And then the person is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. So if you're hiring someone who's like an expert baker, let's say, to come in and help you perfect your cookies, then they should have, if you're going to hire them to do that, they should have their own business so that it's clear that you're hiring business to business. Otherwise, they're typically independent contractors, are typically established in a different trade occupation, or if they're in the same one, they have their own business. Okay. There's a test called the Borello test. With an independent, so this is also how you know whether or not you have an independent contractor. With an independent contractor, with an employee, you have the right to terminate an employee at will for any reason or no reason at all, as long as it's not discriminatory. So you can separate that employment. With a contractor, you have a contract, which is why they're called a contractor. You know that you're going to be working with them for a period of time or for a season, or it's a defined project or defined period of time. Okay, and then We're looking at whether one is performing services and is engaged in a distinct occupation or business. So what kind of work are they doing, and are they doing it for themselves as a business, or are they only working for you? Okay, here's more about the occupation. We're asking whether the work is usually done under the direct supervision of the business owner, or if they do it themselves without supervision. So the CPA, you're not supervising them, they're doing it themselves, right? And then typically the worker will supply their own tools and their place for doing the work. Maybelline, this is that delivery that was supposed to come for 2 hours ago. So let me go get that real quick. I'm so sorry. I will be right. Should we hear? Okay, so people have a distinct occupation, and the work is typically done someplace else, not on site with the business that has hired them. There's more skill that's required, like a CPA has a different skill, it's a particular field. You also look at the length of time for which the services will be performed. With a contract, there is a set period of time or a project that's being worked on. And then they also look at the method of payment, whether it's by time or by job. Employees are paid by the hour, by time. Typically, contractors are paid by the job or by the project. They will also look at whether or not the work is performed as a part of the regular business function. So again, making cookies, are you doing that regularly? Or is it doing the bookkeeping of the business, which is a function of working on the business, but it is not a regular part of being in the business, okay? Typically also contractors work on the business, they work at a higher level, they're doing the management, sort of administration kinds of things. Employees are typically working in the business, making the business go. And then we look at whether or not the parties believe that they are creating the relationship of employee or contractor, employer, employee, or contractor. Now, this last one, even though they say that, the courts typically don't care what the intention was. They'll look at the factors to see whether or not someone should actually be paid as an employee. I think there's a couple reasons for that. They say that they're trying to protect employees. I do think that that's kind of true, but also Social Security is supposed to dry up. And I think that they want more people to be employees so that Social Security can be funded. So that's I won't say conspiracy theory, it's just a theory, but I think that there's probably some truth to that. So when you think about this, how does this impact your relationships? Think about, like, every worker you hire is presumed to be an employee. But if you choose to hire someone and pay them as a contractor, they should have their own business entity, perform work outside of the scope of your business, be free from your control and your direction. Like, you're not telling them what to do and how to do it. You're just asking for the job to be done, and have a written contract. Okay, make that very clear. So what's the solution then? The solution is really to hire employees or to hire business to business. And I know that there are a lot of people who are now freelancing and creating their own work. There's been a wave of encouraging people to start their own LLCs or corporations, even if they're the only one in the business, so that they can be presumed to be a business to business hire and you can pay them as a contractor, instead of the presumption is that they would be an employee. Okay, and then we have to make sure that they meet some of those factors that are enumerated in Borrello, which I just covered before, that shows that they're an independent contractor. So here are some things, 3 things you should consider if you're thinking about skipping the employee classification. The penalties for misclassifying workers as contractors can result in civil and criminal penalties. So it is serious, despite people saying, because I know it happens, because I've heard it before, oh, it's okay, just hire them as a contractor, just pay them under the table, nobody will know, right? That's fine if nobody knows. The problem is somebody could know at some point. And so the civil penalty for misclassifying an employee as a contractor is $5,000 up to $15,000 for the willful misclassification. Now, they probably have defined willful, but willful is typically when someone knows better or should have known better, and they did it anyway, right? Additional penalties, so let's say they got caught one time hiring someone as a contractor and they should have been an employee, and then they do the same thing again. They get caught again. These additional penalties could be anywhere from 10 to 25,000 that can be assessed against a person or employer who has engaged or is engaging in a pattern or practice of misclassifying employees. Now, the thing about this labor law is that typically we have business entities because the entity will protect us from any lawsuit or any judgment. When it comes to employment law and paying people, if you pay them incorrectly, that is a personal responsibility. So the business entity, you could use your business funds to pay for it, but it would be a personal consequence against you that you would have to address. So because of that, and because we typically I would say we typically think that it's not a big deal. Some people think it's not a big deal. They go, well, who's going to say anything? So I thought I would tell you how employers get caught, right? They get caught when someone gets injured at work. Workers' compensation claims tend to also bring about labor claims. And what happens is an employee gets hurt at work, they go to the doctor automatically asks, hey, were you working? The employee says, yeah, I was at the bake shop and I cut my finger, right? An employee is supposed to be covered by workers' compensation insurance. The state will not cover injuries, or they will seek to get reimbursed from injuries when they have occurred at work. You can only get workers' compensation insurance when you have employees. So if a worker goes into the ER or goes to the doctor and says, yeah, I cut myself while I was at work, and you don't have workers' compensation insurance because you paid them as an independent contractor, that is one way you're going to get caught. What does that mean? That means that you will have to pay them the correct wages that you should have paid them. You'll have to pay for the injuries, and you'll have to pay for any penalties for not having had workers' compensation insurance along the way. So you're going to have to pay for, if someone is injured, you're going to have to pay for it anyway. Employers get caught when they fail to pay overtime. I have a friend of mine who has a cleaning business in California. She also happens to be an attorney. One of her employees, his daughter, thought that he wasn't being paid correctly. And so his daughter came to him and said, hey, you need to ask her for overtime. And then the daughter got on the phone with the owner, and they eventually worked it out, but it wasn't even the employee that had a complaint. It was the family member that thought that something wasn't right. And so then that could, if they would have gone to the labor commissioner, the employer would have had to defend against, whether or not she had paid overtime, whether or not the wages were correct, all of that stuff. But this happens typically if, an employee is working, a worker is working 10 or 12 hours and someone goes, man, don't you get overtime? They go, no, I'm an independent contractor. And someone plants to see, well, maybe you shouldn't be an independent contractor. Maybe you should be an employee. What kind of work do you do? Let's go to the labor commissioner. It's free, right? Employers also get caught when they fail to give meal or rest breaks. Again, one or two that get skipped, your employee is probably like, okay, but when it's a pattern, or when they feel like they're overworked or they're upset, then they're going to the labor commissioner, and the labor commissioner says, okay, well, how are you paid as an employee? Oh, I wasn't paid as an employee. Well, only employees get meal and rest breaks. And then it starts an investigation into your practices and payment habits of contractors versus employees. So those are three ways that people typically get caught. So I would say assess the business risk, or analyze the risk. For many small businesses, they think it's cheaper to hire contractors, no payroll service fee, no payroll taxes, etc. But the penalties can be $5,000 to $25,000 depending on how many people are misclassified, what you should have known, what you can prove that you did know or didn't know, right? And then also think about business growth. Typically, employees have a little bit more investment in the business than an independent contractor, because an employee wants to keep the job, they want to get a raise, they want to see it grow, because it also means that there will be more money in their pocket as well. So you bring them in, kind of make them feel like a part of the family, and typically they will give you some of that same energy back. But I will say in the last couple of years, the employment landscape has changed a little bit. So I'm not too sure where people's motivation is anymore post-COVID. Okay. Any questions about that before I go into how do you actually bring your workers from under the table?
I do have a question. So we're clear, let's say we hire someone, as you said, to do our taxes or to keep our, an account. So when it comes, to the payment of that person, does the labor laws apply to that, or do they have to be bounded by the contract? Because there's supposed to be a contract in it.
Yeah,
Like,
so that you could pay that person as a contractor because they're working on your business and they're using a separate skill than what you're doing in the business. So I have a CPA, an accountant that I hire to do my bookkeeping and also my taxes at the end of the year. I'm paying her business to business. Typically, they will also have their own businesses. Let's say it's a bookkeeper that's just, doing it on the side. That's okay too, because it's a different service than what you're doing in the business. So you can just pay them the straight rate that they ask for.
Okay, and those, just to clarify it a little more, let's say that the rate is $10. The length of the payment of those things is usually stated previously in the contract, and that's what they are supposed to go through. It doesn't go through the labor law, to the labor law. Okay.
So
Thank
you mean
you.
with a contractor?
Yes.
Yeah, so contractors, they're not subject to labor law in the same way that employees are. So if I'm doing work for you as an attorney, right? I can do legal work for you because you don't have a law firm, so you can pay me as an independent contractor. It would be the price that we agreed upon in our contract together. So there's no, if it takes me 10 hours longer than, or let's say I spend 12 hours in one day working on the project that I'm doing for you or working on the task I'm doing for you, I don't get overtime. I don't get time and a half or double time because I'm not your employee. You're just paying me whatever it is that we agreed upon in our contract, and that's it. That also means I'm responsible for paying my own taxes. I'm responsible for reporting my income. You give me the check when I'm done with the work, and then you don't think about it anymore.
Thank you. Mercedes?
Yeah, so I have a CPA whose functions for us is just maintaining our books and doing our profit and loss and balance sheets. We currently don't have, like, quote unquote, a contract with her where both parties have signed, but she's been working for us and with us for 2 years now. And so do I introduce a contract for her professional services and for what the expectation is from year to year? Or do we just maintain that she bills us every, annually? The payments are being exchanged to our business account. We don't, if we Zelle her, it is through our business accounts.
Okay.
But I just, I want to make sure moving forward, just in case there's some kind of mishap, that there's something in writing, because we do not have it.
Yeah. Does she do work for other businesses?
Yeah,
as well?
this is her profession.
Okay. So I typically always advise on an agreement, but I would say because you all have been working together and you know what it is, if there's a dispute, the judge would say, well, what was the pattern of interaction beforehand? And every year you're probably having her do the same stuff. And so it's going to be easy to prove from a past pattern of behavior, easier to prove because you all have been doing these 5 things at this rate for the last 5 years, right? Or the last 3 years. Moving forward though, I always think that it's good to get what the expectations are in writing.
Sure.
I get it. I get it. Sometimes it's just easier to just go ahead and get started, but especially like if you're having a website designed or something like that, or someone's doing a branding project for you, definitely put that stuff in writing and be really clear on what the expectation
Yes.
is. Some people will say, I'm only doing 5 pages for your website, but you need 15 because you've got, 4
Right.
different offers and 8 employees, all this stuff, right? Or maybe they'll put up a web page, but it's ugly and they only have in there 2 revisions and you didn't
Oh,
realize that, right?
yeah,
So
the details. Okay.
yeah, so as much as you can when you're working with other people, put the details in writing so everybody knows what the expectation is. But I would say in this particular instance that you gave me, I think you're okay to continue as is. If you switch to
Okay.
somebody else, put it in writing so that there's
Well, I'm also asking too, because the probability of us having a second location is gonna definitely require like her
Mhm.
services plus more. So at
Yeah.
that point, we probably need to introduce a contract
Yep. I
for
think
the
that'd be a good
legal.
time to do it. It's a good
Okay.
smooth transition.
Okay, good. Thank you.
Yeah, no problem. Good question. Any other questions? Okay. All right, well, feel free to interrupt me whenever you need to. All right, so your next steps for actually bringing your workers from under the table. So if you're paying people under the table now, the first thing you need to do is to choose a payroll company. If you choose something like Gusto, and probably most of them now, you can also put your contractors into your payroll company and you would put them in as a contractor. I think probably QuickBooks has payroll too. Um, there's a number of companies out there that have payroll. Now you could also like Gusto, QuickBooks, you don't have much support. It's pretty much like they have the software, you do everything. There are other companies like Paychex, ADP. I don't even know if ADP is still around, but they offer a little more hands-on. And they'll take time to get you set up. And some companies like Gusto, like Paychex, they also have an added HR package that you could add on to if you want to, or you could do that separately, or you could just do it as needed. So I would say like ask around and then just really compare and see what it is that you want and need. Like how much support do you want versus how much are you pretty savvy about it or know someone that you can go to if you have an issue. I would create a hiring packet. So when you know that you're getting ready to hire somebody, you've got all of the like 10 basic documents that you need, from the wage notice to the offer letter to the I-9 form to all the consent form, all of this stuff that's down here. So you don't have to scramble each time you get ready to hire somebody. You're going to give a copy to them and you're going to keep a copy for yourself, for your records, noting when the person received it and that you also have a copy and that you gave them a copy. I would wait to do an employee handbook until you're really clear about what your policies and steps are. Handbooks can be really, really good. I think if you're newer, you're still figuring stuff out. And if you have a policy, like let's say you have a late policy, but you never enforce it, and then you want to terminate someone because they're late, one of the hurdles you're going to have to overcome is how come you didn't enforce the late policy before, right? Let's see, can you share a hiring packet with the group? Yeah, I do those. I have hiring packets as part of the service that I offer. And contracts too. So contracts, I think, I mean, you can get templates for contracts. One of the reasons why I think it is advisable to work with an attorney on creating a contract, even if it's a template for you, is so you can understand how to update the contract when you need to. So I think it is good to work with someone for your first template, like your first template hiring packet, and then you know what to change. You know what documents you need to update. If it's another year, you know you need to go to the website and download the 2025 version of this document. But sometimes when you're doing it yourself, you don't know enough yet. So I think it is worth it to have that education first, and then someone can tell you how you can update it. But there are templates and there are contracts that are available, but it presumes that you know what you're doing first. Okay, I would also attend any employment law trainings that you can that are related to your industry. Some law firms will do them for free. Some business accelerators will do them for free. Sometimes the local law library will do them as well, just so you can stay updated on the changes in employment law that are happening. And then I would consider, depending on how many employees you have, especially if you think that there might be some turnover, and like just busyness, consider working with an HR professional and or an attorney that's well versed in wage and hour laws, particularly for restaurants. So you want to make sure someone is on top of what's happening in the industry, what the new trends and what the new changes are, so that they can advise you when you have a situation that comes up that is, you know, unique to like having a food truck, right? Or unique to working out of a commercial kitchen and then taking, you know, items to another place to sell. Okay, I think my slides won't advance anymore, so I think that might be my last slide. I can't believe I didn't have a slide that said any questions. Either that or my computer has a, yep, it didn't do it. Okay, so the last slide is, do you have any questions? I don't know why it's not advancing. Oh, well. See my recently shaky Zoom screen share skills. How do we connect? That's a good question. I have an email, Asha at the Wilkerson Law Office.com. You can send me an email there, and then we would just make an appointment to get on a call, Zoom call, to discuss whatever it is that you need. If it's something within my realm, within my expertise, then I can help you with it. And if not, I know plenty of people that I can refer you to who are experts in their area. Can you give us a ballpark idea of how much it costs to work with an attorney to create a hiring packet? So I typically charge about $700 to $1,000 for the hiring package. It depends on how much is needed that's in there. Like some people want a couple of policies that are in there. Some people are like, nope, no policies, just give me the basics. So between 700 and 1,000 for me. And I'll walk you through it and make sure you understand what needs to be done, how to update it on your own. And I would say probably come back and check in with an attorney about every 3 years, just to make sure it's still relevant, because things are changing pretty quickly. Yeah. Any other questions? All right, well, that's my employment law basics overview. It's definitely something to pay attention to because you need employees to grow your business. And when something doesn't go as planned, you can feel it. You can feel it. So I think it's definitely one of those things that's worth it to put some time and attention to on the front end. So on the back end, it'll be smooth sailing. And if something comes your way, you're going to have the documentation to back it up. There was a client that I worked with for a handful of years, probably 3 to 5 years. And she had all of her stuff in a row. She had an HR company that was working for her, but she had lots of, like 25 employees at some point. And inevitably, there was always someone who would say something or do something a little strange and, you know, would file a claim and we would win the claim because there wasn't much there, but she had to defend it. And I was really, really happy for her that she took the time to have her documents, you know, tight, her I's dotted and her T's crossed, because she was able to defend herself and could do it quickly and clearly. So it's not to say that nothing will happen, but it's also to be prepared in case something does happen.
Any other questions?
Well,
I
I'm
had a
really
question.
excited for you. Oh, okay, go ahead.
Sorry.
Mhm.
So I know earlier you were talking about we have to have things written down, like if people were to like want to waive a lunch and things like that. So
Mhm.
if we were to have like a slow day and we wanted to send an employee home, is that something that we would need to have written down as well? Is that kind of like that we could talk about it with the employee?
Yeah, I think it depends on how many hours they've worked. So if they end up like only working for 2 hours, but they were scheduled for 8, then I think you would have to pay them 4. I will double check on that. Because if they're counting on a set number of hours, then there needs to be some kind of notice that they won't be working those hours.
Okay, sounds good.
Yeah.
Thank you.
That's a good question for sure. I'm excited for you all. It's a lot of responsibility to be an employer, but it's also such a great like noble responsibility. I think, you know, you're employing people, like you're putting money in people's pockets. I think that is such an amazing thing and an amazing achievement to be able to do it. You've grown your business to the point where you can help someone else support themselves. So you all should be very, very proud of yourselves, because it is no small feat. So kudos to you all. Hats off to you all.
Well, thank you so much, Asha. Thank you for that amazing advice at the end and cheer up. I want to say more than an advice. It was more like a cheer up, and I love that. And thank you for the information that you just shared. Really happy again for you and your move to Portugal. I hope you can. I hope you can figure out the language situation really soon.
Right.
And if nobody else have any other questions for Asha, I'm just gonna let her go. And then I'll keep you guys for another 2 minutes, and I'll also give you your day back.
Thank you, Jody. Yes, please don't hesitate to email me. I put my email in the chat. Like, just stay in touch. Let me know how you're doing, and I will be available. And if I'm not, I will send you to someone who is, for sure. It's out of my expertise. So, all right. Enjoy the rest of your day. Thanks for having me.
Thank you, Asha. Bye.
You're welcome. Bye.